Now, the panelists of today, I'm very thrilled that they very enthusiastically accepted my invitation, have all presented during the very first season of the SCL lecture series, back in the spring 2003. And I thought it would be apt to ask all three of them back at the Instituut and to reflect on and take stock of the International Criminal Justice Project and whether it's sufficient or deficient, a discussion that plays an important role in the more specific context of the ICC these days as well, but that, in my opinion, goes much further than that. Now, the three panelists with a background in the academic world and the world of practitioners will reflect on the main theme, taking three different perspectives: so international criminal procedure, the right to information, and critical reflexive learning. And after the presentations, which will take some 15 minutes each, there will be ample room for Q&A, so please hold your questions until the end. The first speaker is Goran Sluiter. He's Professor of International Criminal Law at the University of Amsterdam, and he's also Professor of Criminal Law and Procedure at the Open University in the Netherlands, as well as a lawyer and partner at Pack & Oliveira Human Rights Lawyers. He studied law at the University of Maastricht and obtained his PhD in International Criminal Law at Utrecht University. He joined the University of Amsterdam as Senior Lecturer in International Criminal Law in 2004 and became a Professor in International Criminal Law in 2006. And Professor Sluiter is Principal Investigator in the Vichy-funded research project Rethinking the Outer Limits of Secondary Liability for International Crimes and Serious Human Rights Violations, which runs from September 2018 until September 2023. And between 2006 and 2011, he was principal investigator in the VD-funded research project International Criminal Procedure in Search of General Rules and Principles. And tonight, Professor Sluiter will speak about international criminal procedure, how good is good enough. The second speaker is Ms. Olga Kavran. She's currently the head of Outreach and Legacy at the Special Tribunal for Lebanon, as well as a lecturer on public international law at the American University of Beirut and the American University of Science and Technology, also in Beirut. Prior to the STL, which she joined in 2010, she has worked for nearly 14 years at the ICTY, the International Criminal Tribunal for the former Yugoslavia, in various positions as a translator, outreach deputy coordinator, and spokesperson for the prosecutor. And she has an LLM in Public International Law with a specialization in International Criminal Law from Leiden University in the Netherlands, and has published and taught on the topic of international criminal courts and tribunals and international criminal proceedings. And Ms. Kavran will speak on the development of justice, international criminal courts, and the right to information. And our third and last speaker is Dr. Jeff Handmaker. And since 2007, Jeff Handmaker has taught law, human rights, and development at the International Institute of Social Studies in The Hague, which is part of the Erasmus University of Rotterdam. And as a social legal scholar, he studies the social and political dimensions of mobilizing law in relation to a variety of contexts and themes, including in his 2018 book, Mobilizing International Law for Global Justice, co-edited with Karen Arts and with contributions by Marti Koskiniemi and others. And from the early 1990s until early 2000, he held various positions for the South African organization Lawyers for Human Rights, and subsequently worked on many assignments around the world as a consultant, trainer, and researcher based in The Hague, developing particular experience in Israel and the occupied Palestinian territories, Morocco, the Netherlands, Malawi, Suriname, and Zimbabwe. And in 2017, he was a visiting research fellow at Princeton University. He maintains a long-time association with South Africa as a visiting research fellow at the Faculty of Law at the University of Witwatersrand in Johannesburg, and as an editor and editor-in-chief of the South African Journal on Human Rights. And he's also a project board member of the Public Interest Litigation Project in Amsterdam. And Dr. Handmaker will speak about the legitimacy crisis within international criminal justice and the importance of critical reflexive learning. Now, I would like to thank all three of you, of course, for being with us here tonight. And Johan, you have the floor. You may stay here or stay seated, but you briefly.
Okay, well, thank you. Thank you, Christoph, for introducing me and for inviting me. I actually did not remember 15 years ago. Actually, 16 years. And it's a good moment, I think, to look back. But you can do that, I think, every day now and every year in international criminal law. 2019 is also, for example, the year where we look back on 25 years since the ICTR has been established, and also 25 years since the ICTY has become truly operational. Taking a step back, much can be said about what happened in ICL since the first lecture, Supranational Lecture series. At the same time, it's also very tempting to comment on the here and present and to deal with some of the troubling recent developments in, for example, within the ICC. I talk about the Afghanistan decision, and I will immediately say I will resist that temptation. I want to say a few words about the development of international criminal procedure over the past period, and especially as far as the ICC is concerned. International criminal procedure, how can we describe it? It works to some degree. Other qualifications, it is good enough, or it is as good as it gets. However, in my view, good enough does not do it, and we should constantly aim at maintaining and improving the procedural laws and practices. As time progresses, we note that international criminal procedure is in need of that maintenance in a number of areas, and we risk to, the longer we wait with dealing with that maintenance, we risk to make it more and more difficult to keep international criminal procedure up to speed and to make sure it is efficient and fair. There are two, I could go on for hours on this, but I will not do that. But there are two areas of concern I would like to raise with you. And the first deals with the procedural principle of legality. As you may know, precisely 2 years ago, I think in April 2017, the Constitutional Chamber of the Kosovo Specialist Chambers issued a judgment in which it determined whether the rules of procedure and evidence, the draft rules, were in conformity with the Constitution of Kosovo, that is, and that Constitution makes a lot of reference to human rights, so it was basically a human rights assessment. These rules of procedure and evidence were drafted by the plenary of the judges of the CICC. Both the content of the rules of procedure and evidence and the evaluation process shed an interesting light on the current state of international criminal procedure. The draft rules of procedure and evidence made a serious effort already to protect human rights in the various stages of the proceedings. And when it comes to the investigations, they provided for more detail in the investigative powers. Investigative powers such as search and seizure operations, wiretaps, taking of DNA, and similar investigative measures. More than has ever been done by any other international criminal tribunal before. However, the Constitutional Chamber still found a considerable number of those rules to be in violation of human rights law, because the interference with human rights, especially the right to privacy, had not been properly regulated and was therefore not in accordance with the law. This ruling puts again on the agenda the principle of procedural legality, and in that light the question whether a similar or even worse regulation of investigative powers within the ICC also violates human rights law. To make it more concrete, what safeguards are there actually in place in case, for example, the prosecution of the ICC wishes that a wiretap is put in place or that a search of someone's home is being done at the national level? If you look at the applicable law of the ICC, there's nothing that can be found on the regulation of search and seizure or on the regulation of wiretaps or on any specific investigative measure. It means that the ICC fully relies on national law and authorities to provide the necessary safeguards for these investigative measures. However, the protection among national systems may differ or may not be available at all in certain systems, or, as also may happen, the national systems may fully rely on the ICC and have the idea that they do not have to have any type of protection in place because there's a request coming from the ICC and they trust that the ICC has properly decided whether or not a wiretap or search and seizure operation needs to take place. The interesting thing is that the message of the CICC Constitutional Chamber, in what I think is, in terms of international criminal procedure, a revolutionary judgment, is that human rights law no longer tolerates this lack of regulation in the framework of the ICC, and that from a human rights perspective, the ICC's lack of detailed procedural regulation is not acceptable. The major question is, will this message be heard? Until this day, I have not seen any serious debate on this matter within the ICC, to my knowledge. I do see that the KSC judgment has been received and has been applied by the ICC when dealing with issues of release after following the acquittal in I think the recent Bagbo and day-to-day decisions. But there's not been, to my knowledge, any reference yet in ongoing cases within the ICC, but maybe I'm wrong here. The second issue, an area of concern I want to address, relates to my old hobby horse, if I may say so, and that is issues of cooperation. The procedure on cooperation. If we look at Part 9 of the ICC statute, we see a model that, in my view, is increasingly outdated. It is based on the interstate cooperation model, which is also referred to as a request-based model of cooperation. However, since 1998, since the text of the Rome Statute has been adopted, we have seen more and more modern models of cooperation that have emerged and which are far better than the outdated Part 9 compromise. And a very interesting example is the EU model of cooperation in criminal matters. This model within the EU is not based on a request system, a request and compliance system, but on mutual recognition. And in light of the importance of the ICC and taking into account its relationship with its members, an ICC model based on recognition, of course it cannot be mutual recognition because it would be unilateral recognition that the member states recognize the authority and the judicial orders from the ICC on a direct basis. Such a model of unilateral recognition would have made more sense than the model we now have in Part 9. It would also provide for a far more direct and more efficient system of cooperation. If a judicial order coming from the ICC would have to be considered as an order coming from a state party's own national judicial authorities. Within the European Union, both the European arrest warrant, which dates back to 2002, and very recent and not so known yet, the European investigation order, which emerged in 2017, are exemplary modern tools of improving cooperation. It could serve as a role model for the outdated and problematic Part 9 compromise in many respects. There is, for example, far more attention to matters of legal protection in the European arrest warrant model and especially also in the European investigation orders. It is thus not only about efficiency. The European investigation order contains, for example, interesting and very pertinent provisions that an investigation order can only be issued when it has been determined that requirements of necessity, proportionality and subsidiarity have been met. Another fascinating aspect of the European investigation order is that it gives the state of the art and regulates modern investigative measures. There are rather detailed sections on hearing witnesses by video conference, DNA taking, interception of telecommunications, and all what is necessary for a modern investigation. It thus also connects to the previous point on issues of legality. A more detailed and better structured cooperation law, as is the case with the European arrest warrant and the European investigation order, will ensure better compliance with human rights requirements in terms of invasive investigations, that they have to be in accordance with the law. So there's a lot that the ICC could learn from modern developments in cooperation in criminal matters. Now, where does this leave us? What we should not forget is that international criminal procedure is like national systems in constant need of maintenance. We cannot leave it there and forget about it. Some maintenance is extremely urgent, and I think this relates to the human rights requirements which I just discussed in respect of the issue of procedural legality. Other maintenance is more about making procedure proof to the demands of modern and technological societies. These were my observations. Thank you.
Hello, everybody. Thank you very much for inviting me here. I'm very honored to speak on the topic that is quite dear to me, having worked in the public information departments of the different tribunals over the years. And that is what I see as a developing right to information that is directly linked to what the international courts and tribunals actually do. So I just have to say at the outset that the views expressed here are my own and not necessarily those of the SDL. And those of you who work in the international tribunals know why it's very important to make these points at the outset. So, Jeremy Bentham, a couple of centuries ago, said something about the transparency of the proceedings, the sentiment of which obviously stretches to this day, even if the technology with which we receive information and are able to follow criminal trials has dramatically changed, as is our understanding of human rights and other related rights. And of course, holding public trials is about protecting the rights of the accused, but it is also about holding the public servants, as it were, in the form of judicial officials, to account and providing transparency of proceedings. So what we will discuss this evening is, what I would like to discuss this evening is three related rights. Right? The right to a fair and public hearing related to the right to information, and finally the emerging right to truth and how the different international courts and tribunals are discharging this right and what may have changed in the meantime or what may need to be done in the future. So in terms of the right to a fair and public hearing, I'm sure all of you know very well that they're enshrined in Article 14, for example, of the ICCPR, Article 8 of the American Convention of Human Rights, and other documents. However, there is a fair amount of literature on the fairness, right, of proceedings. There is quite a dearth, if I can say that, on what it means to conduct a public hearing. Of course, there are different exceptions that are allowed in terms of conducting a public hearing, but there's nothing, these have been elaborated, but not so much in terms of what does it actually mean to conduct a public hearing. For example, if is it enough to have a public gallery to which people can come and observe the proceedings, which may be perfectly okay in a national setting, but it may not be applicable in an international setting where the courtrooms are, because of the nature of the work and the situation that we have, usually thousands of miles away from the people who are most interested in and most affected by their work. So in terms of the comments, again, to further explain the Article 14 of the ICCPR, all trials must in principle be conducted orally and publicly. Then there's a need affirmation that the publicity of hearings ensures the transparency of proceedings and thus provides an important safeguard for the interest. So there is an affirmation of the necessity, but again, no detail as to what it actually means. Further, it says that a hearing must be open to the general public, including members of the media, must not, for instance, be limited to a particular category of persons. So there's some detail that's provided in the general comment. In various cases, for example, of the European Court of Human Rights, the court has held differently that holding court hearings in public constitutes a fundamental principle enshrined in Article 6. The public character protects litigants, and so on. So basically, they have reaffirmed the right, but without and provided some more detail in some of the other cases, in terms of, for example, the public must be informed about the date and the place of the hearing. That if the courtroom is not large enough to accommodate spectators, the state is under an obligation to take compensatory measures in order to ensure the public and the media are duly informed. That even expensive transport was seen as having a clearly discouraging effect on potential spectators, and that the authorities should have provided regular transport. So in terms of the European Court of Human Rights, they have given some interpretation as to what it might mean that you are in fact conducting public proceedings. Moving on to the issue of the right to freedom of expression and the right to information. Article 19, with which you are familiar, I'm sure, the freedom to seek, receive, and impart information. Then, which was explained further by the Special Rapporteur on the protection and promotion of the right of freedom of opinion and expression as the right as not merely a corollary of the freedom of opinion and expression, but a right in and of itself, which is very important as well. In terms of, the Special Rapporteur went even further to say that this right imposes a positive obligation on states to ensure access to information. And I'm stressing all this again because these are all developments over the years that go in parallel with the development of international criminal justice, right? So whereas this issue back in 1993 was one that was not so prominent in terms of the right to information, today in 2019 the situation is vastly different. The joint declaration of the 3 special mandates on freedom of expression of the United Nations Organization for Security and Cooperation in Europe and Organization of American States stated that the right to access information held by public authorities is a fundamental human right, which should be given effect at the national level through comprehensive legislation, based on the principle of maximum disclosure, establishing the presumption that all information is accessible, subject only to a narrow system of exceptions. The Special Rapporteur went even further later on, saying that public authorities should be required to publish proactively, even in the absence of a request, a range of information of public interest. That systems should be put in place to increase the amount of information subject to such routine disclosure, and that access of information is a citizen right. Furthermore, as a result, the procedures for accessing information should be simple, rapid, and free or low cost. And finally, the third right, which is relevant particularly, emerging right, I would say, which is relevant particularly to international tribunals, is the right to truth, right? And the set of, excuse me, the set of principles for the protection and promotion of human rights through action to combat impunity reaffirm the inalienable right to know the truth vis-a-vis gross human rights violations, where the international criminal tribunals are seen as tools for ensuring the right of the truth, and this in the words of the Office of the UN High Commissioner for Human Rights. The Special Rapporteur for the Promotion of True Justice Reparation. In the aftermath of repression or conflict, the right to truth should be understood to require states to establish institutions, mechanisms, and procedures that are enabled to lead to the revelation of the truth, which is seen as a process to seek information and facts about what is actually taking place, to contribute to the fight against impunity and reinstatement of the rule of law. A lot of this wording is repeated in the documents establishing the international criminal tribunals and courts, as I'm sure you will have seen. So, although it can be argued that the international criminal courts and tribunals are not technically bound by these conventions, they of course aspire to uphold the highest standards of international justice and the highest standards of human rights. So the argument would be that they would want to, of course, be conforming to the highest standards of upholding the right to information, for example. So what have the tribunals and courts done? In most cases, in the statutes and the rules of procedure and evidence, it is stated that all proceedings before a trial chamber, other than the deliberations, shall be held in public unless otherwise provided, that the judgments will be pronounced in public, that the accused, again, these are some examples, but they're pretty much all the same in terms of the different statutes and the rules. The accused shall be entitled to a fair and public hearing, subject to measures ordered for protection of victims and witnesses. And again, as an exception to the principle of public hearings, again, we have the issue of protection of victims and witnesses and other specifically prescribed exceptions. Interestingly, in an example of great foresight, the first modern international tribunal, the ICTY, back in 1993, immediately established a public information office, which was not at the time a common office to have in national courts. So in many respects, this was a very forward thinking of people at the ICTY. However, at the same time, this public information office only operated in the official languages of the court, which were English and French at the time. So it wasn't until 1999, which was 6 years after the establishment of the court, that the then president and other people in the tribunal realized that there was a gap, a significant gap, between what was going on in The Hague and the understanding of what was going on in the region of the former Yugoslavia. Now, of course, many different elements feed into why that was the case, and certainly it's not only because of the lack of providing information in the local languages that this gap existed, but one issue was certainly the fact that although the tribunal was very good about providing information to the media, it wasn't really communicating with the public on the ground. So in 1999, the ICTY established an outreach program specifically designed to address the people in the former Yugoslavia in the local languages, to address misconceptions, to establish a two-way communication with the tribunal, and to explain the work of the tribunal in a way different to simply issuing statements for the media or issuing information about the work of the tribunal for the media. Only a year later, in the reports of the Secretary General on the establishment of the Special Court for Sierra Leone, it was stated that if the role of the Special Court in dealing with impunity and developing respect for the rule of law is to be fully understood and its educative message conveyed to Sierra Leoneans of all ages, a broad public information education campaign will have to be undertaken as an integral part of the court's activities. A little bit later, in a report commissioned by the UN ECOSOC, it was said that effective outreach programs are essential not only to ensure that people are aware of and understand prosecutions and why certain charges were brought, but also so that the judicial officials are aware of how human rights prosecutions are perceived by ordinary people, and to ensure that public perceptions are not distorted due to that. So the reaffirmation of the necessity of this two-way communication. In the Secretary General's report on establishing the STL, it was said that the key element for the success of the Special Tribunal is not only that justice be done, but also that justice must be seen to be done, and that the development of an effective and comprehensive outreach program bringing the activities closer to the population of Lebanon and the wider region is a priority. And the next two slides are from the 2008 report of the Office of the United Nations High Commissioner for Human Rights, entitled Rule of Law: Tools for Post-Conflict States, Maximizing the Legacy of Hybrid Courts. And it says that a successful outreach program necessitates receiving and sharing information seeking to integrate a hybrid court into society, and that providing timely and accurate information is a matter of policy and transparency, which in turn reinforces legitimacy, because hybrid courts require more explanation than existing judicial bodies. So this important task should not be left to the local or international media, which is often not able to responsibly deal with these issues, often requiring capacity building. And then it further says that outreach needs to be complemented by the spokesperson and trained media advisor in its activities. So none of the tribunals, until the establishment of the Special Tribunal for Lebanon, and even after, have actually put outreach or requirement for outreach in the statutes or the rules of procedure and evidence. So in fact, the STL is the first one to have included specifically a requirement in the rules of procedure and evidence for an outreach program to be established to disseminate accurate and timely information to the public, particularly in Lebanon, about the work of the tribunal, and to carry out outreach activities related to victims. So in terms of, what is basically the problem is what you might be asking, because right now what the courts and the tribunals are doing is providing timely information to the media about the work of the tribunals. They're providing online usually the transmission of all the proceedings with a 30-minute delay, but nevertheless, all the proceedings are public, or the majority of the proceedings are public. In some courts, the ratio of public proceedings is higher than in others, but that also has to do with the nature of the different trials. They're also providing regular press releases that have a very serious web presence, and so on. However, the fact remains that all of this is in fact done without a regulatory framework as such, which brings the danger of some of these measures simply being arbitrarily stopped because of budgeting issues, because of decisions of people who might not be so forward-thinking, and so forth. Basically, without a regulatory framework, a lot of this can be discontinued for arbitrary reasons, right? So although what is being done at the moment at the international level is very good, and a lot of standards have been set, my argument is that this should be codified, right? And transparency should be increased where it's necessary, and where it's sufficient, it should actually be regulated in such a way to leave out the possibility that it's arbitrarily discontinued. And unfortunately, we have a situation where we see, for example, exactly that having played out with the mechanism for international criminal tribunals, which, when the ICTY closed down at the end of 2017, discontinued its outreach program. There's simply no outreach at the MIC. Right? I'm told now that there is a project which might take place beginning sometime later this year, which will perform similar functions to what outreach was doing, but effectively there is no outreach at the MIC. And if you speak to people in the region of the former Yugoslavia, it's a huge problem, because the MIC did have two serious appeals that were going on, plus a very, very important trial that was still ongoing before the MIC, right? So there was a public information or external relations office, but effectively outreach activities such as existed during the ICTY were discontinued. So in order to prevent such things from happening, it would be important to codify these things.
Rwanda? Rwanda?
Rwanda.
That's half of the MIC.
Yeah. But they don't have an outreach program. The MIC has no outreach program on its statute, or in its rules. And it did not get the funding for the ICTY. Outreach always came from the EU, right? Which they didn't even request up until now. Now I'm told that they've requested some funding to conduct outreach, or some outreach-like activities in the former Yugoslavia, but that still hasn't happened.
Not Rwanda.
Not Rwanda, no. So, where can we look for guidance in terms of what could be done? One is a set of principles that were developed by Article 19, the NGO that deals with issues of freedom of information, and it's one of the leading NGOs advocating the freedom of expression and freedom of information. And they've developed a set of principles to set a standard against which anyone can measure whether domestic laws genuinely permit access to official information. What also is worth noting that back in 1990, around the time that the modern tribunals were established, there were only 13 countries that had freedom of information laws in place. Today, that number is well in excess of 100 countries. I think it's 116. And some 25 countries have passed such laws in the last 5 years. So obviously, there's a trend to recognizing that there is a need to regulate this particular area at the national level. And in my view, the same should be done at the international level. So for the purposes of their discussion, a public body includes judicial bodies, and information includes all records held by a public body, regardless of the form in which the information is stored, its source, and the date of production. Okay? And what the principles state, basically, is this number, I'm not going to go into great detail, but basically, maximum disclosure stipulates that freedom of information should be guided by the principle of maximum disclosure, that laws which are inconsistent with that principle should be amended or repealed, because disclosure should take precedence, that meetings of public bodies should be open to the public, again, with the understanding that there are things like the deliberations of the judges in the tribunals, nobody would argue, are something that should be open to the public. But for example, something like what the STL does with the summary of its rules amendment is an important element of providing information to the public, right? Because, for example, at the ICTY, the rules were amended and the public was informed about the amendments, but not about the reasons why, and certainly not about amendments that may have been rejected, right? So some information, there could be always a formula of finding a way for providing information to the public which does not jeopardize the integrity of judicial proceedings in any way, or the work of the judicial institution, but does provide more information about the work of the actual institutions. Another thing, since we have Judge Ray in the audience, that is worth mentioning is the redacted versions of otherwise confidential decisions, which are sometimes tasking on the judges to produce, but are very important. And that has not always been done, for example, previously at the ICTY, where it's understandable, for example, for a decision on why protective measures were put in place for certain victims and witnesses. Obviously, the entirety of that decision cannot be public, otherwise it would defeat the purpose. But the judges can always decide which part of that information can be made available to the public to increase transparency of proceedings. You can add something on that topic if you like later. Limited scope of exceptions, which stimulate that exceptions be clearly and narrowly drawn and subject to strict tests, such as, for example, protection of victims and witnesses in the case of international tribunals. The obligation to publish, there should be an obligation on the courts to publish this key information. Promotion of open government principle. Processes to facilitate access, which stipulate that requests for information should be processed rapidly and fairly, and an independent review of any refusals should be available. Again, something I might mention in terms of the STL, for those of you who might be particularly interested, there's a very interesting proceeding that is outside of the STL's main jurisdiction, which has to do with the detention of certain individuals who were held in detention during the time of the commission that preceded the STL, who were subsequently released because there was no information to hold them by the STL. So that was one of the first decision that the STL made, was release these individuals, who then, one of whom petitioned the STL for certain information relating to their previous detention. And while there was no jurisdictional standing for them to do so, the judges still held that in the interest of fairness, and I'm paraphrasing very broadly, these individuals had no recourse to go anywhere else, and therefore the judges were entertaining that request. And again, I'm paraphrasing very broadly, but just to indicate what you might wish to look at if you're interested, and it's on the STL's website. Costs, which stipulates that individuals should not be deterred from making requests for information by excessive costs, and then measures for protection of whistleblowers. So I will end it there, and I'm happy to answer any questions if you might have them. Thanks very much.
I think I'm just going to sit here. Yeah. Thank you very much to the previous speakers. Thank you very much to Christoph Poulsen from the Asser Institute for organizing this. It was indeed interesting to look back 16 years ago at what we were discussing then, and kind of how we sort of shifted maybe a bit our perspectives on international criminal justice. And in my case, how I felt in that notion of critical reflexive learning and what it means to me, and why I feel it's really important in evaluating international criminal justice now. So in 2003, I was a practitioner, and I delivered a paper indeed the first of the series organized by my friend and colleague, the late Dr. Abraham McDonald. It was a series then also organized with the Coalition for an International Criminal Court. It's interesting, I guess they're no longer involved in the series, but it was very, they all had explosive, but in any event, it was very exploratory, right? Trying to figure out what this beast of international criminal justice was. Of course, the ICC came into existence, the ICTY had been there for some time, but there were really quite new things that were being discussed then. So my paper then was entitled Seeking Justice, Guaranteeing Protection and Ensuring Due Process, addressing the tensions between exclusion from refugee protection, which is the field I've been working in for many years then, at that stage, and the principle of universal jurisdiction. I managed to get it published in the Netherlands Quarterly of Human Rights, and then got more and more involved in academia, and ended up in Social Science Institute, which is a disturbing experience at the beginning, but turned to be quite enriching, in the end. So then I was speaking about a perceived crisis, and that crisis turned out to be very interesting in retrospect, in the international asylum regime, and in particular the restrictive tendencies in this regime. How post 9/11, because this is of course 2003, right? Restrictive tendencies have been accelerated in the US and Europe. I use the example in the Netherlands of 1F exclusions from refugee protection being made, determinations being made before 1C inclusion determinations, and that the UNHCR had intervened in a court case in Haarlem to try and challenge this 1F before 1C measure, claiming that it fundamentally violated refugees' rights. Well, the court disagreed, and this policy was upheld and continues to this day. Furthermore, how this crisis was accompanied by rapid developments in international criminal law, and how these conversations in the field of international law happened in parallel. There was a lack of discussion regarding the tension between competing legal principles, on the one hand protection, on the other hand ending impunity. I argued that it was important to critically examine the tensions between, on the one hand, exclusion from international protection on the basis of serious reasons to believe involvement in international crimes, which of course applies to a wide category of offenses, has a low evidentiary threshold, against holding individual violators accountable for international crimes. Which, as we all know, applies to a much narrower category of offenses and has a much higher evidentiary threshold. So there's a major tension here, right? Exclusion from refugee protection and justice for the victims of international crimes. I also found that there was an illusion of confidentiality, reliance on dubious country reports by the Dutch authorities, and an inability, or actually really a reluctance, to prosecute international crimes then. Things have changed since, and of course Goran Sluiter knows very well how things have changed also here in the Netherlands. I've been involved in some of these cases on universal jurisdictions through the Dutch law on international crimes. So things have certainly improved. It's always nice to see, looking back 15 years. But of course, being the person that I was then, and pretty much now too, I decided to propose solutions, right? The need for better communication, which has been mentioned here, and I thought that was really interesting. And a consistent application of the legality principle, in this case, aut dedere, aut ceducere principle. Of course, what I was writing was largely a doctrinal argument. It was a contextualized narrative of international law, but not very deep. It was problematizing international law values, but again, not very deeply. So that then brings me to the present. A paper that I published last year in a book with a colleague, Corinne Kneel and Bob Jessup, from the Pedagogy of Political and Social Crises. I wrote about the legitimacy crisis within international criminal justice, and what I felt was the importance of critical reflexive learning. Well, I critiqued assumptions that law is impartial, neutral, objective, certain, predictable. Of course, Koskinen has written quite a bit on this. And I observed that while social sciences, my colleagues at the Institute of Social Studies largely shake their heads in dismay at such assumptions, they do remain strongly held values by international lawyers, of which I am still one, including those involved in referring, investigating, prosecuting, adjudicating, and defending international crimes. I noted that the ICC, being the latest and most visible institution, was created to prosecute international crimes, alongside many other international criminal institutions, which of course you've heard about and you know in the whole quite well. I observed also that since its creation, ICC has been plagued by many problems, which have been noted indeed as well by the previous speakers, particularly Goran Sluiter. Technical and resource capacity issues, management problems, Also, and I think you steered clear of this deliberately, the political challenges to its legitimacy. From my country, the United States of America, the bombastic John Bolton with his famous 3 no's, to the Africa group of assembly of state parties to the ICC accusing the prosecutor of Africa bias. I argue that these are, at the end of the day, quite surface level problems. They're accidental, as Bob Jessup would say, a political scientist. It took me a while to figure out what he meant by accidental, but I now have somewhat of a better understanding. But I did argue it was a much more serious problem in terms of this legitimacy crisis is the crude and culturally essentialist way in which the ICC prosecutor, particularly the previous prosecutor, and indeed the NGOs that have been supporting the court, regard themselves, the perpetrators and the victims, survivors of international crimes. How they fail to consider the complex social, political, and cultural context in which these crimes take place. Indeed, we are more or less conditioned as lawyers not to take this into consideration. I felt, and I do still feel that the underpinnings of the ICC and indeed much of international criminal justice are quite Eurocentric. Mikhail Moutou has also written quite a bit about this. And Mikhail Moutou has even gone further in relation to his savage victims and saviors metaphor, which I've also applied in the context of this paper. The key actors in international criminal justice have reduced to simplistic and racialized categories of saviors from the global north, pitted against savages, culturally speaking from the global south, to protect the interests of helpless victims, also from the global south. Rather than speaking merely of the crisis of, I problematize the crisis in international criminal justice as a significant moment of reflection. Again, a political science term, which it took me some time to figure out what Bob Jessup was trying to say. But in the end, after figuring it out, I argued for a critical, reflexive approach for actors engaged in the work of international criminal justice, such as myself, which would involve contextually informed decisions regarding who, when, and how to prosecute international crimes. In other words, an informed use of discretion and an active engagement for the reasons why this discretion is being exercised. Second, and this has indeed been noted, particularly by Goran, the need for cooperation, building capacity at the national level, particularly promoting the complementary role of states to prosecute international crimes, which has not been adequately prioritized by the ICC and its member states. And furthermore, avoiding techno-managerial solutions to complex social and political problems, which of course refers to the work of Koskinian. So my principal message was really that it's important to critically understand the dynamics behind mobilizing international law for global justice, which was another project that I worked on. And I'm pleased to see Maya Kroff from the Conference on International Law, Hague Conference on International Law, who also contributed to this book project. And that there's a need to take the politics of international law seriously, not just its legal legitimacy, as was referred to, but also its political legitimacy, which is a quite different thing. The right to truth, indeed, I noted, listening to your talk, Mr. Rand, is hugely political. Having worked for a good part of my early career in South Africa, with the creation of the Truth and Reconciliation Commission, this was absolutely the subject of political negotiations, and it was a hot potato also when it came to be challenged in the Constitutional Court. But then also in Suriname, where I've been working, looking at prospects for transitional justice there, in Palestine, many different places. It's a very, very political issue. Furthermore, there's a need to gain contextualized understanding of how law functions. To, in other words, have a socio-legal approach to evaluating what's really happening in international criminal justice, also as lawyers, practitioners. To develop a strategic understanding, ultimately, of international criminal justice that transparently engages with these matters, sidestepping, again, transparency, I like that word, sidestepping what are very often simplistic, self-serving critiques that dominate the discussion on international criminal justice generally and the ICC in particular, and really why it's been so important to have this Supranational Criminal Law series, which does look at these issues quite deeper. Upholding higher standards, indeed, was something which also resonated in your talk. That, of course, is very much a political challenge. So what lessons have I learned in relation to international criminal justice and the ICC in particular since this lecture I delivered 16 years ago? Well, 6, and half of which is my identity still as a lawyer. The other as a socio-legal scholar in the field of development studies. So as a lawyer, well, first of all, the reasons why discussions in international law take place in parallel and are often in tension with each other are clearly due to what Martin Koskiniemi in what he also elaborated at his Osser lecture this past year, right? Referred to as the fragmented character of different vocabularies of international law. And it's important to really critically look at law in this way. I mean, it's more than this neutral vessel, and I think most of us who study law nowadays will accept this. Furthermore, that each of these vocabularies has a decidedly political character. You cannot disengage from the fact that both in the creation as well as in their implementation, and of course the extent to which they're resisted, the way in which the principle of legality is resisted, has, of course, a political character. And that most lawyers, and I'm definitely not excluding anyone around this table in this regard, but certainly referring to myself, because this is my lessons, that most lawyers are still reluctant to take the politics of international law seriously. Although much more scholarly work on this, from Koskiniemi's Politics of Redescription to an even more skeptical approaches, including decolonized understandings of international legal values through third world approaches to international law, or TWAIL, have really developed a rich body of critical, reflexive knowledge around how international law, nearly completion. As a socio-legal scholar in the field of development studies, I really do very clearly see law as a cultural system, which, like any other cultural system, is fluid, it's dynamic, it's gendered, it's racialized very often, and above all, subject to elaboration. And this being subject to elaboration is really crucial because, of course, law changes not in a very predictable way, particularly in the field of international criminal justice, to put it mildly. So the gap between what happens in The Hague and what happens on the ground, which is what Olga Kavran was referring to, is, I think, a really good illustration of how culture really matters, both the legal culture of doing international criminal justice, as well as a huge number of external pressures that are brought to bear on those involved in international criminal justice. The fifth lesson, therefore, is then that referring to a crisis of anything is not very helpful on its own. And it's important to problematize how law has addressed itself to crisis, and most importantly of all, we need to better understand how international lawyers learn from how law has been applied to address a crisis. This is indeed the primary justification for the ICC's creation, and is an exercise that I think we need to engage in much more often. So critical reflexive learning is a key entry point for understanding how law can be strategically mobilized in the ICC and other international criminal justice institutions as a legitimate form of counterpower against regimes who would otherwise exercise with impunity violation of international crimes. I do feel that the ICC, and indeed any international criminal justice institution, will be judged not only by its capacity to develop a solid legal jurisprudence, but by its courage to honestly confront the politics of prosecuting crimes by individuals, but also corporations, in the global north. This does bring me to the recent news. And so far it's not looking very good, I'm sad to say, with judges unwilling to allow an Afghanistan investigation, and further reluctance on the Palestine file, despite an abundance of evidence from non-governmental organizations, Israeli, Palestinian, international non-governmental organizations, United Nations reports, an abundance of UN reports, and many other different sources. And that's where I want to end my introduction. Thank you.